This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to speak about why giving up an insurer's right of subrogation cost that insurer $25 million, and why an insurer should get premium sufficient to help when one waives subrogation. The Southern California Edison Company protected itself by requiring its contractors to waive subrogation for wildfire, among other damages due to its own negligence or the subcontractor's negligence. Evanston Insurance Company appealed from a judgment entered after the trial court granted summary judgment in favor of Southern California Edison Company and against Evanston Insurance Company as to Evanston's claim for equitable subrogation, equitable indemnity, restitution, and declaratory relief. In Evanston v. SCE, the California Court of Appeals on September 29, 2023, spoke about its contribution of $25 million to settle claims by property owners against its insured. The original Mowbray's Tree Service, Inc., which was a subcontractor of Utility Tree Service, Inc., under UTS's contract with SCE to manage certain vegetation proximate to SCE's equipment. According to Evanston, the property owner's claims arose out of a wildfire they alleged was caused by a tree hitting power lines that were owned and operated by SCE. Evanston asserted that the wildfire resulted solely from SCE's negligence, not the negligence of Evanston's insured. In its motion for summary judgment, SCE argued that the following waiver provision in Mowbray's subcontract with UTS barred Evanston's claims. Quote, subcontractor waives and will require all of its insurers to waive all rights of recovery against the contractor UTS or the owner SCE, their affiliates, their directors, officers, and employees, whether in contract, tort, including negligence and strict liability or otherwise, close quote. The trial court agreed and entered judgment in SCE's favor. On appeal, Evanston contended that the waiver provision was ambiguous and that the trial court erred in failing to analyze separately whether SCE's waiver defense applied to Evanston's equitable indemnity and restitution causes of action. Regardless, the Court of Appeals concluded that the plain language and context of the waiver provision demonstrated the provision unambiguously precluded Evanston's equitable subrogation claim against SCE. In February of 2015, a wildland fire ignited in Bishop, California on property owned by the Los Angeles Department of Water and Power, called the Round Fire. Evanston alleged that property owners and their subrogated insurers filed at least 10 lawsuits in the aftermath of the Round Fire to recover damages. Evanston asserts that the plaintiffs in the lead action alleged that the fire was caused by a tree that contacted power lines owned and operated by SCE. The subcontractor agreement included the obligation to carry $41 million per occurrence of insurance coverage and to waive its insurer's rights of subrogation. Evanston alleged that during the underlying action, SCE, which claimed to be an additional insured under the policy, repeatedly threatened to bring a bad faith action if Evanston did not pay the full amount of the policy, and it, under pressure, agreed to contribute $25 million policy limit to a settlement, but reserved its rights to pursue full recovery from SCE while ignoring the fact that it already waived by its contract Evanston's rights against SCE or anyone else. The trial court heard and granted SCE's motion for summary judgment. A judgment or order of a lower court is usually presumed to be correct on appeal, and all intendedments and presumptions are alleged in favor of its correctness. Evanston bore the burden of rebutting the presumption of correctness accorded to the trial court's decision, regardless of the applicable standard of review. In the case of insurance, subrogation takes the form of an insurer's right to be put in the position of the insured in order to pursue recovery from third parties legally responsible to the insured for a loss which the insurer has both insured and paid. An insured's contractual waiver defeats an insurer's subrogation claim. The waiver provision at issue appeared in Exhibit B of the agreement, which is a 2-page document entitled Insurance. On the first page and under the subheading Subcontractor's Insurance, the subcontractor agreed to obtain and maintain certain specified policies of insurance and provided that it waived all of its rights and that its insurers would also waive their rights. The context of the waiver provision, according to the Court of Appeals, supports the conclusion that it encompasses claims against SCE that Mowbray's would otherwise have been able to transfer to its insurers. In sum, the plain language of the waiver provision unambiguously foreclosed Evanston's equitable subrogation claim against SCE. The waiver provision was presumably available for Evanston's review when it underwrote the insurance policy for Mowbray's, and it agreed in that contract of insurance eventually issued to support the waiver. Because the waiver provision was found to be unambiguous, the Court of Appeal rejected Evanston's arguments supporting its construction of the provision. When a dispute arises over the meaning of a contract language, the first question to be decided by a court is whether the language is reasonably susceptible to the interpretation urged by the party. If it is not, the case is over, because the Court of Appeals concluded, for the reasons set forth above, that the waiver provision's reference to, quote, all rights of recovery against contractor or the owner, close quote, unambiguously included Evanston's equitable subrogation rights against SCE, the owner. The judgment was affirmed. Respondent, Southern California Edison Company, was awarded its costs on appeal. In my opinion, insurers like Evanston issuing general liability policies often, if not invariably, agree to waive the insurer's right to subrogation. Evanston's policy allowed for the waiver, and it had no more rights than its insured, who had waived the right by a clear and unambiguous contract, and caused its insurer, Evanston, to include the waiver. Evanston has tried to change the meaning of the contract on appeal, but was unable to explain why it had agreed to the waiver before the issuance of the policy if it did not believe the waiver language was clear or unambiguous. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog and will receive notice of every blog posting, usually 5, sometimes 6 a week, and access to the more than 4,600 blog postings. You can also receive free the videos either on YouTube or on rumble.com, and will be advised of their publication. The lists remain with me and no one else and are not sold. You can also, if you're interested and found this video to be useful, to tell your friends and colleagues about the blog and the videos so that they too could subscribe. And if you wish further detail on insurance, insurance law, insurance claims, and insurance fraud, please consider for a small fee subscribing to my Substack publication or my locals community. Thank you for your attention.